Why this Supreme Court website is very slow? Is this on my machine or it is happening? Oh, oh, Supreme. Just I am going to this option, advocates at advocate on record examination. So, well, now my objective is the previous year question papers. Just let me find out some questions, maybe this place. Before that, I would like to open this volume 1. And especially the head notes of the Sharad Birdi, what I want. Where is that? Yes, 212. Yes, this is the head notes. My concern part is not the particular head notes. My concern part is this fact. What? This is the fact. Oh, this is the fact is just started from here. Again, I'd like to remind you the first thing. The thing is, this is confined to the circumstantial evidence, conviction on the basis of the circumstantial evidence. Uh, Section 136, that is why it should be interference of this court is warranted into the impugned order. So it says interference by Supreme Court with the concurrent finding of fact of the court below normally not permissible. Special circumstances like error of law, violation of well-established principle of criminal jurisprudence, etc., would be necessary for interference. That is special circumstances. So, what is this special circumstances? That's the error of law, violation of well-established principle of criminal jurisprudence would be necessary. So, these are the special circumstances would be necessary for the basically the tag word is the concurrent finding of fact. So two part is there. One is the concurrent and another is the fact, not law. Concurrent finding of fact of the court below. Next is this is concerned to section 3 of the Evidence Act 1972. Condition precedent for conviction. What should be the condition precedent for the conviction? Based on the circumstantial evidence. And what is the nature, what is the proof required for this? That is called the golden principles, 5 golden principles for the criminal jurisprudence. especially for circumstantial evidence. Where is the onus of proof? Who will prove? Prosecution or the defense? Prosecution must prove every link. First, the role of the prosecution is starts. Prosecution must prove every link of chain and complete chain. Infirmity and lacuna in the prosecution cannot be cured by false defense or plea by accused. A person cannot be convicted on pure moral conviction. See, every time you will find out the moral conviction. But the one word is there in the phrase, which is pure moral conviction. Try to understand the meaning of that. False explanation can be used as additional link to fortify the prosecution case, subject to satisfaction of certain conditions. Doctrine of proximity concept. What is this doctrine of proximity? You need to understand clearly so that you can respond if they will ask regarding this particular phrase. What is this concept? What is this nature? And what is this limit? Which is explained in this particular case. You can find out this doctrine of proximity. Admissibility, which is confined to the admissibility of the sentence and dying declarance under section 8 and 32 of the Evidence Act. Some penal code was involved, that it was the section 300, murder by administration of poison, circumstances that should be looked into before a conviction. Evidence, appreciation of evidence of interested witness, especially that of close relatives of the deceased. So, what is the duty of the court? Where it would be cautious. Now, the benefit of doubt, when two views are possible, the condition is this: when two views are possible. So once two views are not possible, only one views are possible. So benefit of doubt का question ही नहीं उठता on that point of time. So when two or more views are possible, one leading to the guilt of the accused and the other leading to his innocence, the benefit of doubt should go to the accused, entitling his acquittal. It is talking about section 101 to 104 of the Evidence Act. And ultimately, the last point is the examination of accused under section 313. Now, the examination of accused, 313 of the CRPC. So, the circumstances not put the accused to explain cannot be considered for the conviction. So, point is this: how many point is dealt with in the Sharad Birdi? One is the Article 136, when it would be interference warranted. Once we are talking about the Evidence Act and circumstantial evidence, then there are so many things into them. One is the nature and proof of circumstantial evidence. What is the nature and what is the proof? This is also explained here. Who can prove? Burden is shifted on some accused and prosecution. So who will prove it? So who has the onus? Another term is the doctrine of proximity, which is the different concept concerned to the admissibility of this statement. This is concerned to the admissibility of the statements. of interested witness. This word is very famous in our evidence, and we are taking plea. These are the interested witness. So the interested witness, in that point of time, what is the duty of court under Section 3 of the Evidence Act? And benefit of doubt. When it would be extended. So these things are discussed, and ultimately the 313 of the CRPC, IPC is already done, Evidence Act is already done, Constitution Article 136 is already done. Now the things are Section 313 of the CRPC. So these are things is discussed into them. But before that, the most important part is the fact which is concerned to the case. Just a minute, just a minute. A lot of people are waiting to get in. No, it's okay. So now I'm coming to the assignment. What was the assignment? I'll show you and I'll find out. If we will see the Sharad Birdi's fact of the case, which is narrated into the head notes, not concerned to the law laid down there, fact, which itself says lightly and properly where I want to focus, I'll come to the focus point only. From here, it is the case number and accused number 1 and 2 and relatives and all and all and all and all. These are the background of the fact. Pre-conviction background. What is the relations among them? That is written there. Now, I'm coming to this point. All the three accused were charged for the alleged offense of murder by poisoning on the night of this of Manju, the newly married wife of the first accused, and the appellant herein. Under section 302, section B 302 of the IPC, read with section 120. I need not explain of all these section 302 क्या है 120 B क्या है, all of you are lawyers, so you are aware about that. So 11-12 जून 1982 की रात में परिवार वालों ने न्यूली मैरिड लेडी मंजू को पॉइजन दे दिया और उसको मार दिया. शी वाज डेड. Accused number 3 was also charged. अब देखिए, so these are the event happened. Now what was the charge? Accused number 3 was also charged under section 201, read with 102B. एक accused को 201 सेक्शन के अंदर भी चार्ज किया गया, रीड विथ 120 भी. 120 भी हर जगह लगा हुआ मिल करके अंजाम देने के लिए, वेल प्रॉपर कॉन्स्पिरेसी के साथ. The whole case wasted on the circumstantial evidence. Ultimate story is mapping from all the fact is here. Based on certain letters alleged to have been written by the deceased to some of the witness. डिसिस्ट के द्वारा कुछ विटनेस को कुछ लेटर लिखे गए थे, एंड अदर स्टेटमेंट ऑफ डिसिस्ट टू देम एंड द मेडिकल रिपोर्ट. सो द कन्विक्शन का जो बेसिस बना है, इट वाज सर्टेन लेटर्स other statements of the deceased which is amounted as dying declarants before death. And third is the medical report. So these are the basis for the conviction. What is that? Certain letters court relied on during the trial, some other statements, which is the dying declarants, and third is the medical report. So मैं ये कहूं कि इस पर्टिकुलर पैराग्राफ के अंदर घटना घटी, ये पर्टिकुलर पैराग्राफ के अंदर पूरी ट्रायल हो गई और ट्रायल में इस पर रियलाइज करते हुए अब कोर्ट का जजमेंट आ रहा है, वो देखिए अगले पैराग्राफ में ट्रायल कोर्ट का। ऑन द एप्रिसिएशन ऑफ द एविडेंस द ट्रायल कोर्ट फाउंड ऑल द थ्री एक्यूज्ड गिल्टी एज चार्ज्ड, convicted them accordingly, and sentenced the appellant to death under section 302 IPC, and all the three accused, not only appellant and all the three accused, 302 में डेथ सेंटेंस अवॉर्ड किया गया, and to rigorous imprisonment for 2 years and a fine 2000 each under 120B IPC, but did not award any sentence under section 201 read with 120B. 201 के अंदर रीड विथ 120 में कोई अवार्ड नहीं किया गया, अवार्ड किया गया और कन्विक्शन दिया गया आपको 302 और रीड विथ 302 के अंदर 302 रीड विथ 120B। ये इंपॉर्टेंट पार्ट। कितने को कन्विक्शन मिला फिर से आप देखिए, ऑन एन एप्रिसिएशन ऑफ एविडेंस the trial court found all the three accused guilty at charge, comma, convicted them accordingly. So all the three are convicted. This is the conclusion what we can find out from this much paragraph started from here up to here। हमारे काम का सिर्फ ये पैराग्राफ है कि ट्रायल कोर्ट ने किया क्या, किसको किसको किया, एकदम प्रिसाइसली। ऑल थ्री आर कन्विक्टेड under section 302, sentenced death for 120 IPC 2000 each fine, but did not award any sentence under section 201 read with 120B। ये हमेशा आपको समझना पड़ेगा कि दिस इज द फोकस लाइन। क्या चार्ज था और कन्विक्शन कहां हुआ? चार्ज यहां पर था 302 अंडर सेक्शन 302 रीड विथ 120B and section 201 रीड विथ 120B। एक सेक्शन में अवार्ड होता है सेंटेंस, दूसरे सेक्शन में नहीं होता, दूसरा पार्ट में नहीं होता है, ये माइंड करने वाली बात। नाउ appellate and the other two accused यानी तीनों फाइल क्रिमिनल अपील अगेंस्ट देयर कन्विक्शन एंड द सेंटेंस अवॉर्डेड टू देम। हाई कोर्ट में अप्लाई हो गया। स्टेट के अंदर भी स्टेट ने भी कह रहा है कि फाइल ए क्रिमिनल रिविजन enhance the sentence award to accused 2 and 3। Oh, where is that? So just read it again. Convicted them accordingly and the sentence the appellant से, sorry यहाँ से अलग line है, थोड़ा सा misspell मत कीजिएगा, जरा समझिएगा. Sentenced the appellant to death under section this, and all the three accused to rigorous imprisonment for 2 years and a fine. So only appellant को डेथ था, बाकी तीनों को अलग सेंटेंस. करेक्टेड. सो स्टेट तीनों ने वहां आगे अपील किया और स्टेट filed the criminal revision application for enhancement of sentence awarded to accused 2 and 3. The appeal as well as criminal revision application was heard along with confirmation case number 3 together by the division bench by the Bombay High Court, which was allowed. The appellant appeal in part, इसको relief मिला है कैसे? Regarding his conviction and sentence under section 120B, but confirmed his conviction and sentence of death awarded under section 302. This is confirmed. However, under this is allowed. So allowed the appeal of the accused number 2 and 3 in full and acquittal them. कुल मिलाकर के 2 and 3 को एक्विट कर दिया गया और कंफर्म किया यहां एपलेंट और एक्यूज नंबर 1 के कन्विक्शन एंड सेंटेंस ऑफ डेथ को. एंड डिसमिस द क्रिमिनल रिविजन ऑफ एप्लीकेशन. Hence, the appellant alone came up before the Supreme Court after obtaining a special leave. So, only convicted person is appellant number, accused number 1, which is the appellant. बाकी सारे छूट गए तो उनको आने की जरूरत नहीं थी. सिर्फ और सिर्फ appellant नंबर 1 जिसको डेथ सेंटेंस अवार्ड किया गया था और कंकरेंट फाइंडिंग थी दोनों के अगेंस्ट, इसके अगेंस्ट. मतलब ट्रायल कोर्ट ने भी इनको डेथ सेंटेंस अवार्ड किया था और हाई कोर्ट ने भी कंफर्म किया था his conviction and sentence to death. Now, I would like to map the fact ऊपर जो हमने डिस्कस किया था. Can you say that why this word was written here? Concurrent finding of fact of the courts below. What is the concurrent finding of fact? Trial court convicted, awarded to death. High court confirmed, not disturbed. Clear है ना? Or is there any doubt? Kindly map with the fact of the case. Now, what was the circumstantial evidence? 3 evidence. It was centric on that. Later, which is the document, statement, which is the oral evidence, that the dying declarance of the accused itself. Third is the medical report itself or document. It was the basis for the conviction. Now, there were 3 accused convicted before the trial court. 2 is acquitted and 1 is confirmed. एक एक्यूटल का भी केस बीच में, एंड 120 का चार्ज लगा हुआ, 120। So 120 can it be in the isolation? 5 लोग मिल करके किसी काम को अंजाम देते हैं और 4 कहते हैं कि नहीं तुम इन्वॉल्व नहीं थे, 5वां है। Who is others? Either some book someone or it will go into the abeyance itself would be the doubtful। आप देखेंगे वो सारी चीजें आपको फैक्ट में मिल जाएगी जो यहाँ पर है। मैं इसलिए कनेक्ट करना चाह रहा हूं कि ड्राफ्टिंग में आपको ऐसे ही कनेक्ट करना पड़ेगा और ये आपके ब्रेन में बैकग्राउंड में क्लियरली होना चाहिए, खुल करके नहीं लिखा जाएगा और वहीं से बनेगा क्वेश्चन ऑफ लॉ। सो अब जरा हम रिवर्स करें, तो रिवर्स में आपको मैं सीधा सीधा ये फैक्ट दूं और फैक्ट में खास करके ये पैराग्राफ, यहां से एक लाइन जो ट्रायल कोर्ट की फाइंडिंग है और ये दूसरा लाइन यहां से है जो रिवर्सल बाय द हाई कोर्ट और इवन कन्विक्शन बाय द हाई कोर्ट। ये इंपॉर्टेंट पंच मतलब फोकस पैराग्राफ है आपके लिए। बाकी ऊपर थोड़ी बहुत बातें कही गई हैं वो भी इंपॉर्टेंट है, बट मुझे और आपको चैलेंज करना है हाई कोर्ट का ये ऑर्डर बिफोर दिस कोर्ट विद इन द एसएलपी और अपील वॉट एवर इट मे बी। आप एक चीज और यहां पर ध्यान दीजिए, लास्ट लाइन अभी तक आपने देखा, but confirmed his conviction and sentence of death awarded under section 302। मैं सिर्फ इस पॉइंट पर आ रहा हूं, डेथ अवॉर्डेड। हाईली डिबेटेबल टॉपिक है इस ग्रुप में और थ्रू आउट और अमॉन्ग दोज हु इज अपियरिंग फॉर द AoR एग्जाम कि डेथ सेंटेंस की जो अब यहां बनेगी, क्या बनेगी, अपील बनेगी या एसएलपी बनेगी। Why not 134 आर्टिकल 134 ऑफ द
Certificate, like
अपील बनना क्यों नहीं चाहिए?
the certificate was required. High Court.
अरे मैम, दैट इज द प्रॉब्लम अजय जी, दैट इज द प्रॉब्लम। मैं जरा मैम को थोड़ी सी खिंचाई कर लूं। हाउ कैन वी सो कैजुअल ऑन द कंडीशन? इज दिस मैंडेटरी कंडीशन अंडर आर्टिकल 134? 134 के 3 क्लाउज हैं, 134A,
HS.
134B, 134C और सबके बीच में एक शब्द लिखा हुआ है और। लेट अस चेक इट।
First is reversal, second is withdrawn.
अजय जी मैं उसी लाइन पे हूं, आई एम कमिंग बैक टू दिस। अरे अजय जी अभी प्रॉब्लम ये है लोग कंडीशन भूल रहे हैं, बताइए। एंड दैट इज द कंडीशन ना, पार्ट ऑफ द कंडीशन विद इन कंडीशन। हाउ कैन वी फॉरगेट दिस कंडीशन, और कंडीशन को भूल करके कैसे हम मतलब आगे परस्यू कर सकते हैं, बताइए, कुछ बचेगा ही नहीं फिर। ये तो एजम्पशन है कि आप लोग इसको याद रखें, अदरवाइज फिर तो बार बार यही गोल गोल घूमते रहेंगे हम लोग। कितनी बार और बड़ा फेयरली हमने क्लेरिफाई किया हुआ है, स्पेशली फोकस करके देखिए ना। मैं आज के सेशन में अजय जी, मैं एक ही चीज पॉइंट आउट करना चाह रहा हूं, हाउ यू आर फॉलोइंग आवर इंस्ट्रक्शन। पहला कहा असाइनमेंट, कुछ नहीं किया, किसी ने नहीं किया। दूसरा कहा कंडीशन, कथा सुन के चले गए, उस पर भी कुछ नहीं किया, नहीं किया। आई एम नॉट सेइंग टू एनीवन, आई एम सेइंग टू एवरीवन कि कहाँ फोकस करना है, उसको आप सुन करके इग्नोर करेंगे तब तो फिर मुश्किल है, मुश्किल है। आपको मैंने कई बार एनालाइज किया है। वंस वी आर टॉकिंग अबाउट आर्टिकल 133, 133(1) A, what is this? The appeal shall lie to the Supreme Court from any judgment, decree, or final order in a civil proceeding of a High Court. The condition is the civil proceeding. Condition is what? The any judgment, decree, or final order. No interim is there. Final word is there. The nature of that. In the if the High Court certify under article. So condition is also after that. This if condition is also that the civil proceedings only. Consider is also that the high courts only, not others, other court. Article 1/3 that, and the nature of certificate is further loop into loop. Condition is the certificate. If certificate is there and the condition of certificate is how much? This, that the case involves a substantial question of law of the general importance. And the word here is and. That in the opinion of High Court, the said question need to be decided by the Supreme Court. So these two part is mandatory for the purpose of certificate in the part of the certificate, and certificate itself mandatory. And the other mandatory part is the civil proceedings. And the forum should be the High Court, and the order should be any judgment, decree, or final order. Then appeal. So that much condition should pass. Any condition will fail, does not allow the appeal under Article 133. Now I am coming to Article 134, where and word is not there like this. जैसे यहाँ पे and है ना, यहाँ नहीं, यहाँ पर है or. This is the or and this is the or. Two or connecting three lines, three different parts, creating option to you either A or B or C. Anyone should match. An appeal shall lie to the Supreme Court from any judgment, final order, and sentence in the criminal proceedings of a High Court in a territory of India. If High Court, so the condition start from here. If further condition, पहला कंडीशन तो है ही कि अपील से लाई टू द सुप्रीम कोर्ट फ्रॉम एनी जजमेंट, final order, not any order. And again the word is or, sentence. In a criminal proceeding, this is another condition of a high court. Forum should be the high court only. No any tribunal, no other court in the territory of India. And also, if, so इतने condition match करने के बाद, further condition is this: if the high court, अब मान लीजिए कि हाई कोर्ट नहीं है, कोई अलग फोरम है, ये अप्लाई होगा नहीं होगा. सो दिस कंडीशन डज नॉट फुलफिल. क्रिमिनल प्रोसीडिंग्स नहीं, कौन सी क्रिमिनल प्रोसीडिंग्स वहां पे होगा नहीं, बिकॉज देयर इज अ क्रिमिनल प्रोसीडिंग्स ओनली. यहाँ एनी जजमेंट, जजमेंट नहीं है, कोई ऑर्डर है, वो होगा इंटरिम ऑर्डर, द आंसर इज नो. एडजॉर्नमेंट ऑर्डर नहीं होगा, ओनली फाइनल ऑर्डर इज or sentence. Anything can be challenged, but the limit is that you can find out from here. Has on appeal reverse an order of acquittal of an accused person and sentence him to death. So sentence awarded by the High Court to acquitted person. If appeal reversed an order of acquittal, acquittal को reverse करे. This is one way. Acquittal to death ही होना चाहिए, डेथ टू एक्विटल नहीं होना चाहिए. यदि कोई डेथ अवार्ड किया है ट्रायल कोर्ट और उसको हाई कोर्ट एक्विट कर देती है तो ये अलाउ नहीं है. वन वे ओनली, एक तरफ से गाड़ी जा सकती है, उधर से आती नहीं है. एम आई क्लियर अप टू दिस पॉइंट और नॉट? Of an accused person and sentence him to death. क्या ये कंडीशन मैच कर रहा है? यहां तो डेथ ही था, ट्रायल कोर्ट ने अवार्ड किया है, रिवर्सल है. आंसर इज नो. आंसर इज नो. ये क्लाउज लगेगा, अप्लाई होगा, द आंसर इज नो. हैज विड्रॉन फॉर द ट्रायल बिफोर इटसेल्फ? आंसर इज नो. नॉट विड्रॉन, कंप्लीट ट्रायल वहां होगा. Whether the High Court has given the certificate under Article 134 fit for, and the nature of the certificate is that this case is fit one for appeal to the Supreme Court. उतना ही चाहिए. क्रिमिनल में, सिविल में अलग नेचर का है. यदि पूछ देगा कि सिविल एंड क्रिमिनल के सर्टिफिकेट में डिफरेंस बता दो तो आप तो कुछ कर ही नहीं पाएंगे. यहां तो फोकस ही नहीं है. तो क्वेश्चन यहां क्लियर है. Does this 134 will apply? The answer is no, because of the reason, जैसा अजय जी ने अभी कहा, रिवर्सल नहीं है, विड्रॉन नहीं. विड्रॉन एंड कन्विक्शन. हैज विड्रॉन यहां और के बाद आइदर दिस और दैट, हैज विड्रॉन फॉर ट्रायल इटसेल्फ. Any case from any court subordinate to its authority and has in such trial convicted the accused person and sentenced him to death. What I captured in this case, only word death. Sentence him to death. Sentence of death. अब बताइए कहां कहां हम लोगों को अलर्ट रहना पड़ेगा? डू वी आर अलर्ट? डू वी हैव कीप इन माइंड कि कहां हमको अलर्ट रहना है? हमने इतनी लाइटली अपने दिमाग में इस कंडीशन को लगा रखा है ना कि अच्छा चलो अपने आप आ जाएगा, ये हो जाएगा. हम सीरियसली ले ही नहीं रहे इस कंडीशन को. प्योरली कंडीशन के बेसिस पर चलता है, कोई भी फैक्ट पे कहीं नहीं लगता. एकदम कंप्लीट क्लियरिटी रिगार्डिंग कंडीशन एंड इट्स एप्लीकेशन होने चाहिए. यदि प्रॉपर कंडीशन, सेट ऑफ कंडीशंस मैच करेगा तभी वो लगेगा. कल भी मैं कोर्ट में था, कुछ लोग मिले और उनका ये कहना था, सर मुझे समझ नहीं आ रहा था यहाँ अपील होगा या एसएलपी होगा. हमने उसमें अपील लिख दिया, हमने उसमें एसएलपी लिख दिया. व्हाई दिस कंडीशन इज अराइजिंग? बिकॉज ऑफ दिस पार्ट. And how do we fix such kind of confusion? We will fix from this part only. Yes, sir.
Sir, one more condition is 134A certificate. So if the certificate is not issued, ultimately it goes to the SLP. Even in the above two condition, one of them is there.
Again, you are in vain. What I am showing. See here the or.
R is
What does
there,
it mean
sir.
or?
R is there. In between the R is there.
So what is the meaning of that or? Certificate is required.
So this disjuncture,
So certificate is required or not?
then no.
No, then the matter is closed. Simple.
Okay.
Once the A is not matched, B is not matched, C is not matched, the condition is out. 134 is not applicable.
But R is in between. Okay, right, sir. Right. Right, sir. Got it.
The clear decision is 134 is not applicable here. Appeal would not go. And nor in this section 2 of the enlargement. Criminal jurisdiction enlargement. वहां भी नहीं बनता है बिल्कुल वहां पर वो डेथ नहीं है अजय जी मैं अभी छोड़ूंगा उसको इंटेंशनली मैं छोड़ूंगा कि वहां पर जाकर के बाकी लोग देखें अभी यकीन मानिए whoever is leading towards the successful candidate for the AoR exam they will certainly examine without saying anything उनको मन में लगेगा कि ये कंफ्यूजन का सोर्स वहां रह जाएगा और उसके बाद भी नहीं होता है then I'll again handle it practice and procedure
So my answer should have been that all the three conditions were not there, so that is why SLP is allowed. Is that correct? No?
इस मैंने अपील क्यों है
मैं अपील अगर
अपील
ये
क्यों नहीं है मतलब क्वेश्चन ये है तो
नहीं
एसएलपी और अपील में क्वेश्चन ये है कि यदि अपील जाएगा तो एसएलपी जाएगा
नहीं
और यदि एसएलपी जा रहा है और तो एसएलपी को आगे जाकर के अपील ही बनना है तो आपको दोनों ऑप्शन दिया जाए अपील फाइल किया जाए या एसएलपी आप क्या फाइल करना पसंद करेंगे एक स्टेप पहले या एक स्टेप बाद ऑब्वियसली आदमी अपील फाइल करेगा वो एडवांस स्टेज है ऑलरेडी आपकी राइट है वहां पर एसएलपी में राइट क्रिएट किया जाएगा बाय वे ऑफ ग्रांटिंग द लीव तो अपील पहले फर्स्ट प्रेफरेंस इज अपील तो आप वहां चेक करेंगे ना एसएलपी में यहाँ फर्स्ट प्रेफरेंस अपील लाई करता है या नहीं अब क्वेश्चन ये है कि जब तक आप इस क्वेश्चन को फेस नहीं करेंगे अगले स्टेज पे आप पहुंच ही नहीं सकते या आप ये चाहते हैं कि ब्लाइंडली इस स्टेप को ही वॉश आउट कर दें एक टोकरी में बंद करके और कवर्ड के नीचे डाल दें देखना ही नहीं है इसको देखना ही नहीं है जांच ही नहीं करना चेक ही नहीं करना कि ये लाई करेगा या नहीं मेरे कहने का मतलब ये है कि आप चेक करें और चेक जरूर करें कि ये लाई करता है तभी आप ये डिसाइड कर पाएंगे कि यहाँ अपील जाना है या 136 जाना है आपके ब्रेन में इस पॉइंट को लेके इतनी क्लियरिटी होनी चाहिए कि किस रास्ते ये केस जा रहा है वाई 136 और वाई अपील once appeal is there no need to go through 136 am I clear up to this point or not why we will think कि ये चेक हमको करना चाहिए थिंक करने का एक साफ रीजन है और वो रीजन आपके स्क्रीन पे है यहां देख लीजिए साफ सुथरा तरीके से यहाँ पर क्वेश्चन के फैक्ट में लिखा हुआ है सेंटेंस ऑफ डेथ अवॉर्डेड जैसे ही डेथ की बात आती है हमारा दिमाग खटकता है यस डेथ तो 134 में भी था क्या वो 134 क्या डाउट 134 की तरफ सिर्फ ये सेंटेंस ऑफ डेथ लीड नहीं करता द आंसर इज यस सो वी नीड टू कंफर्म इन आवर माइंड कि नहीं डेथ है लेकिन इसके अलावा दो कंडीशन डज इट कम फ्रॉम द हाई कोर्ट यस डज इट क्रिमिनल प्रोसीडिंग यस डज दिस द फाइनल ऑर्डर यस डज दिस सेंटेंस यस सो कुल मिलाकर के ये सारे कंडीशन मैच करने लग गए फटाफट ये फाइनल जजमेंट है फाइनल ऑर्डर है यस सेंटेंस फाइनल है यस क्रिमिनल प्रोसीडिंग्स है यस हाई कोर्ट इज देयर यस इतने सारे कुछ मैच कर गए तो यहां से यहां तक तो मैच किया क्लियरली। अब अगला कंडीशन देखते हैं, इफ हाई कोर्ट, इज देयर एनी रिवर्सल? नो, so this would not apply. Withdrawn, is there any withdrawn? नहीं। इस दोनों में कॉमन क्या है? हाई कोर्ट सेंटेंस हिम टू डेथ, नॉट ट्रायल कोर्ट। और इसमें क्या है? इवन हाई कोर्ट ट्राइड इटसेल्फ एंड अवॉर्डेड sentence to death. So who awarded sentence to death? The High Court. Now we are on the sentence to death. But in this case, who awarded the sentence to death? Is this High Court? High Court just confirmed. Awarded by the trial court. So this condition would apply here. No. Now what option left? So one is not applicable because reversal is not there, withdrawal is not there. So now next is the third option. Is there any certificate? No. So all option is washed out. So 134 is not applicable. Am I clear up to this point or not? Or is there any more doubt?
This perspective clear, sir. But in the judgment, in the very starting paragraph of this, what to say, head notes, concurrent. Ordinarily, the concurrent opinion of the High Court and trial court cannot be interfered by the Supreme Court. But in 2024, if we observe that Justice Srinivas, Honorable Justice Srinivas Oka judgments, almost all he dealt with the 12 cases in the particular year for death penalty. Almost all except one, all cases were reversed, sir.
Reversed by whom?
Supreme Court. In the sense,
Supreme Court reversed, na?
Yeah, so concurrent opinion of the High Court and trial court. But as per this judgment, initially, that ordinarily Supreme Court cannot interfere with the
So the thing is that just have a look on that. That's what we want to capture. See.
Very first paragraph, sir. I have just.
Yes, of course, yes. Of course, yes. Normally not. Why this word normally is written there? Why this should be written? इसको नहीं लिखना होता तो क्या फर्क पड़ता? Why it is there normally?
The extraordinary situations required.
So what is meaning this? This condition is absolute. The answer is no. Absolute means what? We are the lawyer here. We understand the meaning of words. So normally means what? Normally means
in ordinary situation.
Generally, 99% cases, nahi, but when some things is warranted, we are not so much strict with that. We have the option.
My intention is
we have the option on the case-to-case basis.
Exactly. But here
so
normally
once the fact of the case is warranted like this, invoking our conscience, then we will enter into them. Isn't it? Or is there any doubt regarding that? Question, not only that, even also normally not possible. Normally means what? एक word पूरे मतलब बदलता है. Normally means जरूरत पड़े तो permissible है. अब वो जरूरत क्या है? जरूरत है this special circumstances like error of law and violation of well-established principle of criminal jurisprudence would be necessary for interference. Supplementing to each other. Normally not permissible, but when permissible, वो आगे लिखा हुआ है. That is error of law and violation of well-established principle of criminal jurisprudence. अब आते हैं ओका के जजमेंट पे. जस्टिस ओका ने जो जजमेंट दिया था, क्या उस जजमेंट में उन्होंने रिवर्स करने से पहले ये एस्टेब्लिश किया था कि there is the error of law and violation of well-established principle of criminal justice? The answer is yes. It was noted into the judgment.
But
तो पहला विंडो कहां से अप्लाई होता है सर? Tell me.
Sir?
What I am asking regarding the ओका judgment,
Yes, sir.
जस्टिस ओका जजमेंट्स में जो 12 जजमेंट की बात आपने कही है,
Sir,
have you read the entire judgment?
Yes, sir. Yes, sir. I have so many
So
judgments.
they have recorded where they vitiated from the well-established principle of criminal jurisprudence.
Sir, actually, if we take into
That,
consideration of normal word
hmm,
here,
hmm.
then 99% it cannot be reversed. Am I right? Exceptional cases it can be reversed. But
What is that
Honorable
exception?
Justice Honorable Justice Oka Srinivas judgment, this exception has become the general rule there. This is the exception, but in his all judgment, I think is a human touch. He has
Let me explain you the one understanding, which is the
Yes.
99%. Normally does not mean the 99% or 80% or 10%. What does it mean? I am telling you, and that is the another part which is highlighted on the screen. It might be possible. It might be possible in 100 cases coming from the High Court, and in all the cases, the principle of well-established criminal jurisprudence may be violated.
Yes,
This
correct.
also might be possible. So all the 100 cases come under this special circumstances, or not? Of
Yes,
course,
sir.
it comes. It also might be possible that out of 100, only 2 cases deserve to be fit for this violation of well-established principle.
So second
Only
part of
2 is
this.
deserved to be enter into that window. It doesn't mean the normally words specify into the percentage. Normally words specify into the case-to-case basis on the fact of the case. Am I clear up to this point or not?
Yes, sir, 100%.
So what is the that is depend on the case-to-case basis now.
So you
It
mean to
doesn't
say
mean
that
we have a 20
second
we
part should be
have
copied.
we have 28, 29 high courts, and every high court has the different bench, at least 10 on an average. So decision might be possible 100 case for every month may come like this. And also possible out of 100, at least not even a single case would like this. This is also possible. But as in when this error of law and violation of principle, well-established principle of criminal jurisprudence would be available, and we are convinced, now our role is, we are convinced to the court ki, look, this is the principle and this is the violation and this is the error. Court is entertaining that part, and it must be converted into the appeal. Now the another aspect of this percentage. So Justice O, given the how much judgment was there, 12 or 20? It was around 12, I guess.
Yes, sir. 10 to
12
12, sir.
judgment.
10 to 12.
Did
I will
you
send the
understand
article. One
this?
Hindu paper, one article came, sir. On
Just
before.
listen, sir. What I am speaking, it's not written into anywhere.
So, sir, okay, sir.
But
Okay.
it's a logical, if you, this 12 judgment in bunch, is certainly it would be selected from 2000, more than 2000 judgment to the circumstantial. It's looking like a batch or bunch because of this 12. But the selection of these 12, if you will see, you'll find out the to and fro, then you will find out it is selected from not only maybe 2000, it may exceed from 20,000 and 2 lakhs. Now this is the precedent. Attributing extension to this, assisting or growing tree of this Sharad Birdi? That's the meaning of normally, sir. It's not so easy.
So not 2000, 1000 judgments, sir. 10 judgments only. 10 judgments of death penalty. 10
Uh,
judgments of death penalty.
uh.
9 judgments were reversed. Concurrent
Okay.
opinion.
Okay. So
And one judgment only confirmed.
sir, what I am asking you, only this 10 judgment was came to the court.
Only this 10 judgment dealt by the OK, Honorable Justice Sinha Soka.
How can you say the only?
Because
Mane,
in the judgment, that article in the Hindu article,
May I
article is
intervene?
not the perfect man, sir.
Sir,
Article
may I,
is the bullshit. I just hate all these articles. Did you think the entire 10 years of justice only 10
sir, may I say something?
for that?
no, okay, sir. Okay. I am not finding anything.
So
Sir.
only dismiss, how many cases he dismissed? Does this written into that judgment? Report, article.
I will just forward you, sir. I will just forward.
No. What I am asking, just answer me. How many cases they allowed that is written there? Agreed.
Sir, I could not able to hear sir properly. Sound is.
What I am asking, how many judgment he dismissed? How many SLP he dismissed? Does this written into that report? Without looking into them, how can you say it is the 100% allowed?
99%.
Of the reversal and all this.
Okay.
पहले तो आपको वो देखना पड़ेगा ना कि कितने मैटर को उन्होंने डिसमिस किया है.
Other than death penalty, you mean to
वो
say?
डेटा आपके पास है ही नहीं आर्टिकल में. आर्टिकल में वो डेटा तो उन्होंने लिखा नहीं ना.
Yes, sir. Yes, sir. Other SLPs did not, except death penalty.
तो वो जो है हमारे पास तो 100% दिखेगा ही. What I am saying normally that's a different part. वो मैं ये कह रहा हूँ, जितने भी केस जस्टिस ओका या सुप्रीम कोर्ट के सामने आए थे, क्या वो सारे के सारे अलाउ हो गए? You are saying yes, that is written into the article. How can I believe that?
No, only death penalty I am talking about. Yes, sir.
हाँ, तो जितने भी डेथ पेनल्टी उनके पास आए थे, सारे के सारे डेथ पेनल्टी क्या वो अलाउ हो गए या सारे के सारे डिसमिस हो गए? डेथ पेनल्टी के नाम पे ही सुप्रीम कोर्ट क्या नोटिस कर देती है?
Sir, out of 10 death penalties concurred by the High Court, 9 were reversed. What I mean to say?
अरे sir, what I am asking, how can you say out of 9, 10? How can you say out of 10? Only 10 cases was before OAK.
No, data is there, sir. Data is there. So, Supreme Court observer data is there. Observer in the Supreme Court observer also data is there. And in the data clearly says that whatever the dealt by the Honorable Justice Sinha Soka, that suppose in the year 2024, 10 cases dealt by him only. His bench. He means his bench. His bench. And his bench reversed the 9 by the High Court and
please, I am not convinced with this line. If someone is convinced, they can agree with that. I am not convinced. I do not want to discuss this things at this point.
Sir, I'll take only 1 minute. Give me only 1 minute.
No. I want to conclude it. I want to just conclude it. So this is the unnecessary talk what we are going entered into them. I given the enough explanation. As I understand, more than 10,000 cases dealt with by the Justice Oka, and out of law, we do not know how many cases he dismissed. We do not have any data on that.
Sir, may I say something?
But in the appeal, SLP allowed.
I
So
understood, sir. I understood, sir. I understood. No.
So why are you pressing them? How can you say that 100%?
No. Second part of the sentence.
What is reflection is coming out of that? What reflection is coming out of that? Only 12 cases was came before that. Out of them, 10 is allowed or 11 is allowed. So what does it mean?
What I mean to say, sir, generally when the Supreme Court, Honorable Apex Court mandatorily says that normally not permissible, special circumstances like error of law, violation of well-established principles of criminal jurisprudence, etc., would be necessary for the interference. So
Yes.
this second part is so much important when it should be supplemented to the first part. So it means normally it is not permissible. What my general understanding is that I'm not saying anything wrong, because this is important. Because so Honorable Justice Oka thought that all the 10 cases, the general principles of criminal jurisprudence and that error of law might have been occurred. That is absolutely correct. Unless until it
Yes,
is
sir.
that way.
Might word. See, sir, that is I hate. Simply, I hate. Ask you, have you read the judgment? You
Yes, sir.
said yes. You said yes.
Yes, sir.
So might be कहाँ से आ गया? It would be available into the judgment. Have you read the judgment?
Yes, sir. Yes, sir.
Have they recorded any reason for that? There is the principle of violated.
Yes, sir. Yes, sir. Recorded.
Then it is there.
Yeah.
The
Yeah.
might be. Where is the might be?
Yes, sir. Yes, sir.
So
My general observation I'm
all the
talking about.
cases you read, where he allowed, meaning thereby there was the violation of well-established principle of criminal jurisprudence. Does this not violated, and then he allowed? Then this was the violation of this abnormally. So every cases what he allowed. So all cases will have the special circumstances.
Yes, sir.
So where is the question? It's your understanding which is picking up differently.
You know. Yes, sir. Yes. I got it, sir.
So your confusion, na?
Yes.
Supreme Court and the entire nation is not confused. Just I would like to attribute into them. So these are the 5 things, especially this is 1.1, 1.2, 1.3. They given more detailed about the special circumstances. That I'll also enhance you. Normally, the Supreme Court does not interfere with the concurrent finding of fact of the court below in the absence of very special circumstances. So what is this very special circumstances or gross error of law committed by the High Court? But when the High Court ignores, you see the one circumstances, detailed circumstances, where the High Court ignores or overlooks the crime circumstances and proved fact. This is the one condition. Or violates or misapplies the well-established principle of criminal jurisprudence. दूसरा circumstance. Third, decision rendered by this court on appreciation of circumstantial evidence and refuse to give benefit of doubt to the accused despite fact apparent on the face of record or on its own finding tries to gloss over them without giving any reasonable explanation. So reasonable explanation is the mandate part. Once this is not given and out of record is there, it is automatically come into the box of special circumstances. Or commits error of law apparent on the face of record, which results in another condition is that which results in a serious and substantial miscarriage of justice to the accused. This is the condition. Then it is the duty of this court to step in and correct the legally erroneous decision of the High Court. What I am saying, it's such conditions from across the High Courts within the Supreme Court every month, especially circumstantial evidence and reversal. 1,000, 2,000 cases. See, what data I have, you can verify since 3 years, 4 years back. Within the Supreme Court, total 50,000 cases, 60,000 cases our filing. Now the days is 1,20,000 around cases being filed this year. This year's data. So out of 1,20,000, only 70% regarding that is from the criminal cases, and out of them, if we will divide from the 12 month wise, so 1,000, 1,20,000, yani 10,000 cases being filed, civil, criminal, writ, everything included before the Supreme. Out of 10,000, 7,000, 8,000 are the criminal cases only. And out of them, almost 1,000 cases are coming from the conviction through circumstantial evidence and all. Even the 100 cases for a month, throughout the year, 1,000 cases coming before the Supreme Court. And I'm telling you, I will show you the cases because I'm filing for the purpose of SCLSC matter also, which is the death sentence and life imprisonment is concerned. It is more than 10 years. Almost more than 20 cases I already filed. Court, what is doing in the first day dismissing the matter? First day dismissing the matter. Out of 1,000 cases, almost 900 cases is already dismissed. Rest of 100 issued notice. We do not have any data which 900 cases is being dismissed. Out of 100 among which the notice were issued, after pleadings completed, the appeal is not allowed is around 80. Rest remaining 20 cases, which is going up to final hearing. And out of them, 12 is allowed and rest is not allowed. In batch, 12 is allowed. It's sounding like this. It happened, so many things. It is just sounding. Examine the entire fact is not the only thing. Only 20 cases. It's a very, lost into the entire thing. We are reading the only one judgment in the last 75 years of the Supreme Court exercise. This year only 1,400 judgment is pronounced till the date. Only one out of 80. 80 years constitutions के हो गए ना. कुल मिलाकर के आप ESCR पे देखें, अराउंड 40,000 केसेस इज ऑन द वे. लिस्ट आपको दिख जाएंगे, 35,000, 40,000. 40,000 में ये एकलौता जजमेंट है, बाकी सारे जजमेंट हम देख नहीं रहे. इसी 40,000 में से सिर्फ और सिर्फ 85 जजमेंट, सिर्फ और सिर्फ 85 जजमेंट निकाल करके आपको लिस्ट में लगा दिया गया है कि यू जस्ट प्रिपेयर. Is this the only judgment into the court? If you will say relative to others, then you can have the clear picture regarding that. Otherwise 85 तो 85 ही दिखेगा, उसके बाद तो इससे ज्यादा तो केस हो ही नहीं सकता. परसेप्शन हम क्या बनाते हैं, हमारी अंडरस्टैंडिंग कैसे इवॉल्व होती है और कैसे वो ब्लॉक रहती है और कहां से वो खुलेगी, दैट पॉइंट आई वांट टू एक्सपोज इट. तो 1,000 को जो 12 के पॉइंट पे हम लेकर के आए हैं, उसमें भी जो अलाउड है, डज दिस अमाउंटेड एज आउट ऑफ 20 और आउट ऑफ 1,000? इट मस्ट बी. मैंने आर्टिकल लिखने वालों का क्या है, वो अपने मन से लिख रहे हैं, वो तो बाकी डेटा 900 कौन कौन से केस उनको डिसमिस, वो डेटा ही उनको पता नहीं है, कहाँ से लाएंगे डेटा? वेयर इज देयर कंप्लीटनेस? Virtually they are misleading to the nation, virtually. And that is why I do not like any kind of data. If there's such kind of article to read it, to get mislead ourselves.
No, sir. There is no question of misleading, sir. Please understand that. First of all, Article 134 deal with the reversal of death penalty. Am I right or wrong? Or if so, the Honorable Justice Oka Sinha's judgments dealt by him, there are reasons founded. Nowadays, everybody is towards the death penalty abolition. Almost all 70-80% of the countries death penalty abolished, and in India and some just 5 to 10 countries where the death penalty still is there, and that is a very what to say heinous crime, heinous penalty where we cannot, suppose something goes wrong with the judgment, one cannot get back the life of the individual who was actually hanged to death. So that is the reason they are saying. So as a second part of that, normally not interference, then we have to observe that in this almost all the judgment, honorable judge has given the reasons for reversal. That is important. So when the reasons are there, nobody. But and one more thing is that human touch is also there. Is a very human touch nature judge. That Justice Honorable Justice Hoka, sir, and that is there. Then
See, he was human touch. Just see, we are not talking. We are talking about Justice Oka under the cover of the Supreme Court. So just think about the Supreme Court first. First, and जहां तक मतलब जस्टिस ओका के बारे में भी मैं आपको एक बात बता दूं. If you are making any perception among or about anyone, so there are so many things you have to be considered into your mind.
yes, sir.
If you are not taking so many things, then this is incomplete. So erroneous things are there, and accordingly, see, whoever wrote that article, they never ever thought about on this line. So they cannot create a clear picture. I understand about Justice Oka. He is very much committed to the judiciary. Of course, he was the kind person. He is.
100%, sir.
He is the
100%.
ethical person. That is the one part. The next part, his commitment level is beyond the par.
Yes, sir. Yes, sir. No doubt at all.
Beyond the par. So he, even though I find out certain I have a grievance with this his judgment itself. So because of my expectation from him, because of my expectation from him, but something is misleading to your, and see what I am.
I'm not misleading, sir. I'm not misleading, and
What,
nothing is there. Nothing is there.
सर
Lies, I'm
एक बात
speaking.
मैं आपको बताऊं कि it was 100% misleading. Misleading to understand this word normally. Misleading to understand half-heartedly, read this particular part and stopped here. That was the misleading. You
Probably my understanding.
ignored this word, it was the misleading. So the misleading and fear, two words is the very prominent, and every time will follow you, like your shadow, like your dream, like your imagination, like your breath. Be aware with these two things. Every time it will follow you.
Maybe, sir. Maybe I may be wrong.
Fear word is there. So you can't be, every time it is hidden in your pocket, in your mind, and everywhere. So fear is what? Fear to get insulted, fear to get defeated. So these are also the fear. Not only the life threat is the fear. So many fears are there. For me, fear to narrate, the erroneous thing. Fear to accept the unacceptable thing. It is against fear. So and kind of fears are there. And similarly, the misleading part always following you. Be aware with that.
Yes, sir. Yes, sir. Thank you, sir.
So the so much discussions, dedicated to this particular part only to clarify how this word can mislead. You know how the article can mislead. Did you remember any time in past? Do I given you an article from somewhere for the purpose of consultation?
No, no, sir.
If this
Sir,
is
Supreme Court
published in
observer. Observer. This is the. We cannot say
Supreme
it is
Court
not
observes,
authentic.
sir, I am
Yeah,
telling you the another misleading part. The
sir.
word Supreme Court does not mean it is created by the Supreme Court.
Yeah, yeah. That is a private party, sir. I know very well.
Supreme Court observer is the private party.
Private
Now
party. Private
I
party,
am
sir.
telling you, once I was the computer scientist, I was doing some private job. And in that private part, who is taking care of all this content? These are the very below standard with relative to the Supreme Court, very below standard persons who is managing all this. And artificial intelligence is always doubtful the judiciary. So and everyone is taking their name, putting their name with the Supreme Court. They are observer, it's okay, but they are Supreme Court also.
Yes, sir. Yes, sir. Correct, sir. Correct.
It's a misleading. It's a misleading. That is the problem, sir. So we need to literally careful on that particular line.
Okay, sir. Thank you, sir. Right, sir. Done.
Okay. So see, what is the meaning of this particular word normally? Normally is a narrow window which is taking you into the different world where you need to do certain exercise to correct the law. And those world is hell where lot of rules is violated. You need to correct it and expose it before the Supreme Court. And the normally words literally I am telling you, literally people are making perception it's a percentage ratio. It's not. It is basically the rules implementation centric rather than percentage centric, prevailing that where is the injustice happen. It may be 100%, it may be 1%, it may be 0%, but as and when justice happen, it is invoked irrespective of the fact or ratio. The ultimate point is this. So that's the broader interpretation of this particular word. Now, I am coming to the different part, which was the main objective of the day, that I'd like to enter into the particular, question papers. This is the old question papers. Question paper of 2025. Uh, Let me just go down. See, this is the question paper of 2021. Let me just check it up. I'll focus on the four paper, basically paper 2 and paper. I'll come to straightforward. I'll come back on this part. Just I'll give you the another part. See this question number 7. Is this on your screen?
Yes, sir. Yes, sir.
Is this from circumstantial evidence? What are the 5 golden principles that is the Panchsheel laid down in the Sharad Birdi? What are? Question is what are? For proving a criminal offense on the basis of circumstantial evidence. This is the one part of the question. Another part is what is the additional golden thread referred to in the administration of criminal justice in the said case? And third, would the non-explanation of the sentence under section 313 of the CRPC be a link to complete the chain of the circumstances? So CRPC part is also touched. Additional golden thread is also touched. And finally, the principle of natural justice is also, 5 golden principle is also touched. So this part taken, they never touched about the 136. But these 3 part is picked up for your consultation, convenience. Whether are you able to answer this question? Let us check it out. See, can you see this 3 additional link? I'll show you 3.2. These are the before a case against the accused visiting a circumstantial evidence can be said the fully established following condition must be fulfilled as laid down in the Hanuman Singh 1. The circumstances from which the conclusion of guilt is to be drawn should be fully established. Chain number 1, first principle of 5 golden rules. The fact so established, this is a continuation, fully established. Now, facts so established should be consistent with the hypothesis of guilt and the accused, that is to say, they should not be explainable on any other hypothesis except that the accused is guilty. This is the benefit of doubt. So doubt should not be there, out of doubt. Circumstances should be of a conclusive nature and tendency. Fourth, they should exclude every possible hypothesis except the one to be proved. And fifth, so you can insert this part, any other possibility or hypothesis, this rule would be fracture. There must be a chain of evidence so complete and not to leave any reasonable ground. And after that, these 5 golden principles constitute the Panchsheel of the proof of the case of circumstantial evidence. And in the absence of this, so this was the 3.3. This is the 3.4. And further, I am telling you and giving you the things. Anyway, so this is directly mapping with this question. Can I expect that today you people can write the answer of this question? Year of 2021. Leading cases, question number 4. I need the answer of that. Next part, what I'm going to find out, and that this is the leading case, drafting case. Let us find out some criminal case. This is the criminal case. Section 2, question number 2, option 1. Same year. I'm just passing and I'll find out on the High Court and trial court. This is the learned district judge by its judgment and order. I'm on the para, reading the para 7 only. The learned district judge by its judgment and order dated this, convicted all the accused and sentenced them to rigorous imprisonment of this and this, 10 years, life imprisonment for 302. The learned judge held the prosecution proved the charge beyond the reasonable doubt by proving each circle independently. See, how many accused are there? There are a lot of accused, and it will reveal in the paragraph number 8 itself. The A, B, and C files appeal before the High Court. The contention raised by Mr. A that he is not such and such false implication, and इस तरह से दिया हुआ है. The arrest of A in a manner stated improper, the arrest, recovery of the body, and therefore the disclosure of the statement is not admissible. So the admissibility of the evidence is there, and principle of admissibility is already discussed into the Sharad Birdi. And finally blood stain वगैरह 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 वगैरह. बट हाई कोर्ट के जो फाइंडिंग है वो ऊपर में, the High Court dismissed this appeal. So आपको dismissal के against आता है. There is again the concurrent finding. So इस पे मैं नहीं कर रहा था, मैं सिर्फ एक चीज ये दिखाना चाह रहा था कि कैसे शरद बिरदी चंद वाला कॉन्सेप्ट अप्लाई होता है. पीएमएलए है. So let me go to the another year of the cases. 2021. Let us see the year of 2022 drafting. No, it's not. Let us go back. 2018. Civil appeal. Joint family. Counter affidavit not required. Criminal appeal along with synopsis. अब देखिए हमने क्या किया है, जैसे क्रिमिनल का मैं ये पढ़ रहा हूँ, आई विल स्किप द थिंग फर्स्ट. पीडब्ल्यू वगैरह दिस द केस. अच्छा, यहाँ पर नॉट गिल्ट, हाँ यहाँ से आता है. The case was committed by the magistrate to the court of session for trial after giving necessary copies to the accused. Additional session judge Pune, after hearing the frame the charge of this under section this in 302, 147, 148, 149, 302, read with 34 against all 5 accused placed not guilty, and उसके बाद trial continue. The evidence was put to accused person under section 313 of CRPC, who simply denied all the questions put to them. No one was examined on behalf of defense to the witness. Now, अब उसकी टेस्टिनोमी यहाँ पे आ गई, ये आ गया इन टेस्टिनोमी this the learned, हाँ 10 para 10 learned additional session judge Pune, the trial court, after considering the evidence of record, found that the charge against of the accused person were not proved beyond reasonable doubt, and accordingly acquitted all the 5 accused and his judgment. This, so trial court what he did? Accused, acquitted, and aggrieved, acquitted all the 5 accused, while its judgment and order dated this passed in the session case. Aggrieved by the order passed by the trial court, the state of Maharashtra filed an appeal before the High Court under section 378. The High Court, after considering the evidence on record and hearing the parties, it is the judgment dated this was found infirmity in the finding of trial court in respect of the one accused, and dismissed the appeal to the that extent. However, the High Court found that trial court had erred in law in acquitting the 4 accused, namely this. The High Court gave the following reasons. 2, 3, 4. The High Court convicted the 4 accused under section 302. So what is this case? Acquittal to
Convictions.
conviction. And now what we have to see? We have to see the sentence. So accused for 3 read with this and sentence each of them to imprisonment for life, not to death. So ये क्या बनेगा? This must be an appeal under
SLP.
section no.
Section 2, Section 2.
अरे सर अजय जी, section 2, death is confined by article 130. Section 2 talking about 10 years and above till life, right? So reversal is this. This is the reversal. And not only that, so ground is different is there. So this is the case for the reversal. The one case is there. So just go through it. So section 2 is already written here in the footnote. In last appellate jurisdiction of the Supreme Court in the regard to the criminal matter. और वो यहाँ पर A part is this. Has on appeal reversed an order of acquittal of an accused person and sentenced him to imprisonment of life or to imprisonment for a period of not less than 10 years. बताइए, footnote भी दे दिया आपको. A great hint also.
Obviously, this section only.
तो आप ये देखिए कि मैं ड्राफ्टिंग के क्वेश्चन को पढ़ कैसे रहा हूं. कैजुअल मैनर में मैं पढ़ रहा हूं सर. मैं पढ़ नहीं रहा, मतलब कुछ मैं ढूंढ रहा हूं, समझे? वो ढूंढिए, देखिए यहाँ पर आपको बहुत सारा कुछ दिखेगा। एनीवे लीव इट ऑन दिस पॉइंट ओनली। एक क्वेश्चन और देख लेते हैं ना, 17 का, 17 का चेक कर लेते हैं, लेट अस सी। सेवनटीन का क्वेश्चन नंबर 2, आप देखिए, A1 to A3 were charged with offense punishable under section 143, 147, 148, 3 under 204, 149. The closure report was filed on the FIR by Father A2. The case of prosecution rested upon the testimony of injured eyewitness and medical evidence. The injured cause to A2 remained unexplained in the evidence led by the prosecution. ये क्वेश्चन आप नोट कीजिए, क्वेश्चन नंबर 2 of the year 2017. It is purely based on circumstantial evidence and fully covered by the Sharad Birdi. The High Court reversed the order of acquittal and convicted A1 to A2 for punish under 302. So इसको आप पढ़िए, this is a very interesting question. ढूंढेंगे तो आपको वो मैप करता हुआ चीज भी मिलेगा, but you need to think on this line rather than time बहुत तेजी से क्रॉस कर रहा है. Now we are at in November. Very soon result will come, form will fill up, and पीक ऑफ ब्रेन की जो है ना कूलनेस तुरंत अभी ट्रांजिशन फेज में आ जाएगी एंड विल फील कोलैप्स. कहानी ये है कि नाउ दिस इज द टाइम टू यूटिलाइज केयरफुली एंड सिंसियरली एंड सीरियसली. आप ये समझिए ना, जितना सीरियस हम एग्जामिनेशन के दिन होते हैं ना, दैट सॉर्ट ऑफ सीरियसनेस रिक्वायर्ड राइट नाउ. हर एक छोटी चीज के लिए एक मतलब हजारों लाखों जजमेंट आ जाए. How can we skip all these things so casually? कॉन्स्टिट्यूशन के अंदर और दिया हुआ है, एंड दिया हुआ है, कंडीशंस दिए हुए हैं, कुल मिलाकर के 10 या 15 या 25 आर्टिकल्स हैं. वो कंडीशन भी हमारे दिमाग में नहीं है. 25 आर्टिकल की लिस्ट हमने दी है, स्पेशली इस पर्टिकुलर यूनियन जुडिशियरी से 10 आर्टिकल्स या 15 होंगे मैक्सिमम. एक दो करते हुए 5, 5 10 और 5 15. डू वी एक्सपेक्ट कि इसके सारे कंडीशंस प्रॉपरली ब्रेन में हो, और वी डू नॉट. डू वी एक्सपेक्ट ना, बट डू वी हैव? आंसर इज व्हाट, डू वी हैव. नाउ नेक्स्ट क्वेश्चन इज, इफ नॉट, कब तक कर पाएंगे हम? हाउ मच टाइम इज रिक्वायर्ड फॉर दैट? You will realize no time is required, only focus is required. Precise focus is required, sir. टाइम की जरूरत ही नहीं है. We need to change our casual approach. That's it. आज हमने दो चीज सीखा through the entire discussion, and thanks to सिद्धि सर कि उन्होंने अपने इस एक्सप्रेशन को रखा कि नॉर्मली वर्ड से या जो नॉट इंटरफेयर और इंटरफेयर के बीच का जो विंडो क्रिएट किया जाता है वो कनेक्शन है थ्रू द नॉर्मली, मतलब एक पूरी फील्ड है, ग्राउंड है, चारों तरफ से सील है, बंद है, लेकिन उसमें 3 गेट है जहां से बाहर जाया जा सकता है। स्टेडियम मान लीजिए, स्टिल देयर आर 3 गेट जहां से एंट्री हो सकती है, बाहर एग्जिट हो सकता है। Condition is that if someone on gate, they can in or exit. But पूरे एरिया को देख लें तो पूरे एरिया का छोटा एरिया है, वो कंडीशन मैच होना चाहिए, परसेंटेज इररिलेवेंट है। और आपको मैं बताऊं, पूरी जो पढ़ी लिखी दुनिया है ना, उस तरीके से इस कंफ्यूजन का फायदा उठाती है और नॉर्मली में कंडीशन के बजाय वो परसेंटेज लेकर के घुस जाती है। दैट्स व्हाट द स्टैटिस्टिक्स सो मेनी टाइम्स इज द मिसलीडिंग and confusing, and it's a well deliberated part. Statistics क्यों बना है? With explain the normal thing to ease the life, है ना? लेकिन वही स्टैटिस्टिक्स किसी की कॉन्स्पिरेंसी को कवर करने के लिए भी यूज किया जा सकता है, अपना एजेंडा आगे लाने के लिए भी, एक एज लेने के लिए भी यूज किया जा सकता है। So what I am telling you, very different part of my life or different phase of my life, जिसका एक्सपोजर आज आप लोग हो रहे हैं, क्योंकि आई एम अ साइंटिफिक पर्सन, सो दैट्स व्हाट आई कैन अंडरस्टैंड कि थोड़ा सा साइंस में चेंज करके, स्टैटिस्टिक्स में थोड़ा सा चेंज करके कैसे पूरी तरीके से मिसलीड कराया जा सकता है। और लोग जो है ना, जैसे भगवान में विश्वास करते हैं वैसे ही स्टैटिस्टिक्स को मानेंगे, because they do not have any source to verify it, right? और वो कंफ्यूजन जो क्रिएट होगा ना, यकीन मानिए आपको इस तरह से परेशान करेगा। ये ऐसा, मतलब ये स्वीपिंग पार्ट है जिसको हम कहते हैं इल्यूजन पार्ट है, और यूं कहे मिराज सॉर्ट ऑफ थिंग पार्ट है, जो आपको लगेगा कि नहीं हम कैसे, मतलब कुछ पता ही नहीं चलेगा, लगेगा एनी टाइम यू विल एंटर इनटू दैट डोमेन।
Playing with the words, sir, actually. Words.
Exactly. But I am not on the word, I am on the intent.
No, no, intention is not there, sir. Any, sir, actually,
What
we
I
are.
am saying, the lawyer community, the entire exercise, even the judges, even the judgment, even the everything is on the intent side.
No, sir.
So,
So that
so
word, the
maybe
word disjunction, that word OR, that disjunction makes a lot of difference. You know, in the 134, class 1, class 2, RR, I have gone through it, but even in the class 2 also, R is there
सर
for
मैं
the class 3.
अब मैं एक एग्जांपल सुनाता हूँ आपको,
R is there for the class
especially
3
this is in
also.
Hindi. This is in Hindi. You are talking about and or word. I am talking about comma, sign of comma.
I have not come here.
In one case, it was concerned to the my father. One case, the conviction was happened on the basis of a statement, and the statement ये था कि मारो मत भागो, मारो कॉमा मत भागो। The same thing interpreted into the High Court, मारो मत भागो। Conviction was happened as an accused. Only comma is shifted, the entire set of accused is converted into defender. Maro mat, mane he was for the protection. That's the meaning is being changed.
Yes, sir. Yes.
It's a power of word and playing with the word.
In most of the cases, in one word, in our case, only in 161 statement, one word acquittal came. And and the Honorable
It
High
is a
Court.
shifting of comma. It was not recorded into the record. So that's what we can just put it on our convenience
Yes, sir. Yes, sir.
and interpret accordingly. So the two possible things are there. One possible thing, once the comma is not available, maro mat bhago, comma is not there, then we can construct before the court the comma is not at this place, it would be at this place. And both the court will, prosecution will say, no, 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 comma would be at this place. Maro, comma, mat bhago. It's a prosecution version. What we said, maro mat bhago, it's our version. So two statements and two perception is created, which creates a doubt. One is leading towards the conviction, another is leading towards acquittal. So it's a doubtful situation. So benefit of doubt, as per Sharad Birdi, कहाँ जाना चाहिए?
Accused.
That's the law. So we need to examine all these things very carefully and closely and keep in mind. Keep in mind. बताएं sir. I have done for the day. Now the your terms. I literally struggle to clarify the most complicated part, that is the data connected percentage and with the intent.
Okay, sir. Okay.
It is always misleading and मैं आपको ये बताऊं, मैं बहुत ज्यादा किताबें पढ़ने से परहेज रखता हूं because this is the perception of someone. This is not the core part. बहुत कम. See, if you will read the 15 articles or 25 articles of the Constitution, if you will compile into the page, it will come within 3 or 4 or maximum 5 pages. You have your own mind, and that is the judicial mind. You understand the right and wrong principles of law. So, if you will find out the interpretation on these 5 pages, आपको पता चलेगा ना कि कम से कम 1 लाख केसेस मिनिमम है अक्रॉस द कंट्री ऑन ईच आर्टिकल जो हमने नोट डाउन किया हुआ है उसके बीच में. क्या हमको वो पूरा 1 लाख जजमेंट पढ़ना पड़ेगा टू अंडरस्टैंड दीज आर्टिकल्स, और वी आर एबल टू अंडरस्टैंड दीज आर्टिकल एंड वेरीफाई टू दोज जजमेंट्स? Twice is ours. तो मेरी फोकस होती है कि पहले हम जजमेंट को पढ़ें ठीक से, समझें, सॉरी, लीडिंग प्रोविजन ऑफ लॉ को, आर्टिकल को, सेक्शन को, और इनजस्टिस जहां भी हो रहा है उसको कनेक्ट करें थ्रू द जजमेंट. इस सिनेरियो में क्या होगा, इस सिचुएशन में क्या होगा. आई होप कि आज के डिस्कशन से परसेप्शन थोड़ा सा बदला होगा रिगार्डिंग द नॉर्मली एंड नैरो विंडो and how they are supplementing to each other, how they are opening the narrow window. Any questions? Today I would like to interact with 2 minutes with Dr. Reddy. Sir, you are muted, sir. I think. No, no, not muted, not muted. It's okay.
Yesterday, Dr. Reddy gave us a very good, story to remember the, statues, all statues, 20 statues in one go. It was fantastic.
Now, now, am I audible, Yusuf?
Yes. First,
Thank you.
I must appreciate your efforts and
Thank
understanding too, and respect the understanding.
thank you, sir. Thank you.
What I observed into the other days sessions.
Sir.
So
Sir,
I was feeling sometimes deprived
why, sir?
that even we don't know that much person having understanding such persons is available in our group. And sometimes at the same time feeling pride that they are consistently come here to listen me.
Thank you, sir.
Sir,
Uh,
we are very kids in front of
And
you. And
for the benefit of our legal fraternity, and you have been doing a lot to empower us, sir. You have given us a lot of legal reasoning. It is. Uh, 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 since 2025, I prepared a lot. Due to family emergency, I could not write examination.
sir,
And
the
this 20,
one thing I'd like to appreciate and share with all the group members right now.
sir,
Something is already written into the book.
sir,
Something is already written into the statutes books by the legislator, even the parliament.
sir,
But to understand all these things and apply all these things, the entire system is busy
sir,
and will be busy.
sir,
During those parts, if someone is putting their own mind and creating something convenient for their own understanding,
sir,
it is literally appreciable. It's a rare species. It's a your patentable work.
sir.
जो आप
Thank
अपना दिमाग लगाते हैं ना, and that what you applied for creating or even the memorizing the things, creating
sir,
a slogan and short phrase to
sir,
connect all the thread of that particular part. No one
sir,
is doing like that. Everyone has the brain. So this is the exceptional way which is keeping you bilkul completely different from all.
sir,
Once you are creating this types of efforts, na, it is purely indigenous, your own, your patentable part.
sir,
Why I am discussing this into the group?
sir,
Because it is literally motivation for all. If you will see the book, reading the book, your brain is occupied by book only.
sir,
If I am looking a movie, then my brain is occupied by the movie maker.
sir,
If I am observing a reel, so my brain is hijacked by the reel maker.
sir,
On that period of time, we are not applying our mind. Am I right or wrong? But once you are started applying your mind, अच्छा यहाँ ये है वहाँ ये है वहाँ ये है यहाँ ये है इसका ये वर्ड ले इसका ये वर्ड ले, this is your application of mind, and now you are starting connecting to memorize that.
sir,
It's your work, it's your work, it's your work by
sir,
proper application of your mind. These days what we are doing, 90% time is expending on the hijacked part.
sir,
What I explained little bit earlier, कैसे मतलब दूसरे के सोच को हम जी रहे होते हैं, चाहे टीवी देखो चाहे मोबाइल देखो या व्हाट्सएप देखो, मतलब योर ओन कंट्रोल से बाहर है वो, पूरा कंट्रोल उसके हाथ में.
sir,
But once you are doing like this, taking a pen and connecting something, developing something, और सोच रहे हैं कि क्या बोलना है क्या नहीं बोलना है, this is your brain is under your control. It's your time.
sir,
It's your patentable.
sir.
Choice is yours.
I developed memory techniques in
हाँ,
almost all the
हाँ,
papers. Keywords it is.
हाँ.
So
और ये चीज ये this keywords is, it should be, there should be a certain, dictionary or encyclopedia of such kind of keywords. It would be the highly appreciable. you know Not only that, even the control of your memory, how
yes,
to
sir.
how to come out with the complexity, I came into the simplicity
Yes,
by these words only. It's a connection
yeah,
between these two words. There is
make the
the one
complex
word
into
is the
simple.
very complex, another word is the very simple, calm, cool, and this is the anxiety in the complex word. So these tag word will is a breeze between these two. From
Sir.
complexity, it will take you into this part. So see the impact of these keywords. What you are creating, sensibly you are creating. But be careful on the certain point. It should not be lost. Sometimes so many keywords can be created, but it maybe leads towards the loss. अच्छा इसका उसमें चला गया, उसका उसमें चला गया.
Yes,
It will
sir.
not happen.
So,
So the
so that,
point is this: what I am doing, I also trying to attempting them. So I first deciding this is the point where it would be created. Otherwise, I am just keeping away to create all this.
sir, I
But
submit, sir.
anyway, I heard you. It was a really commendable job,
Sir.
and hats off to you.
No, no.
Sir.
My pranam to you, sir. It is your all
Everyone
inspiration. You are
has to
doing it
do. Everyone has
self-esteem,
to contribute their own contribution by this person.
sir.
Even though, just think about even the organization of all the entire stuff.
Sir,
I never ever said to Ajay ji, ki, please do that. He
sir.
has taken lead their own,
Yes, sir. He has been doing since
organize
two
into
years,
the
sir.
folder, Google Drive, or even in the YouTube, what they are
Sir.
writing. So their own, creation is there.
Yes, sir.
And this is literally helpful for all the peoples. Whoever is
Yes, sir.
here, whoever is in group, and so many person is not in the group.
Sir. And
So that sort of creations will make us very special.
yes,
And
sir.
that's what this group is extremely special.
Sir.
Thank you.
So 1 minute, sir. Regarding, you said that while in the memory detective, you said one point it is we should be careful in the encapsulation of creating capsule form keywords. It is. For
Yes.
that, while encoding also, one should have apply his mind. He should put some minutes of effort. It is.
Hmm.
Otherwise, he'll get it confused. It. ये किसका है, इसका है वो होता. But if while encoding it, if you apply minute of effort, it is carefully, he will never forget in
Exactly.
life.
Hmm.
Otherwise, he will write the question A का आंसर B लिखता है, B का आंसर Q लिखता है. वो इसको happen it gone
Uh,
it. So one while I was telling her, yes, sir, how much time you would give it to me? It took this much of time. So I some of been thinking, sir. And this appeal status appeals, I said it takes in 3 sessions. It is. If I tell in one session, entire things goes away. So for one has to record properly in the mind. It is. If once record permanently, it will records in a conceptual manner. You will never forget it. Sir. So that is the concept memory techniques. And there are several techniques of memory detector. As and when our Yashas was telling it, I was joining and incorporating what is the amulet it is, capsule form, how to remember, keyword is there. Like in the article 131 is there. The 5 words are there, it is. See, I'll tell you, sir, probably for a class. One is covenant, one is
See,
sanad.
what I'm deciding, sir. Just interrupting you. Uh, for the coming exam,
Sir,
for the coming exam, for the very specific part
sir,
of your own expertise,
sir,
I'll keep you indulged when I keep you in loop. So in
definitely,
this
sir.
session, in this main session,
Sir,
I'll assign
please,
you. We'll discuss personally.
sir,
So so that we can just multiply our dimension into and you know to keep the focus on dot
Sir.
of everyone. So that's what I'm planning. Of course, I'll take around a month to think on crystallize
Okay,
on this.
okay. You give me assignment, sir. I'll
But
make it in
once
the.
it will be crystallized, it will go on this particular part. And please, whatever is this, what is my expectation? That is, I also want to reveal. Once we discuss these things, I'm not discussing only the law.
Sir.
I'm not discussing today only the Sharad Birdi. We are focused on how to convert into the marks
Yes, sir.
at this moment, or take advantage into the professional life. Take this little bit age into the professional life. We started discuss the Sharad Birdi, having n number of things, even the 136 or even the circumstantial evasion, 5 golden rules. Then I entered into discuss the one part. One part is the normally with the Siddhi sir. And it was the different line and length and so many things I blocked and ultimately clarified that this is the problem can be raised by that. Now you are aware that one word, how their windows is opening and how this is the things are there. Then we discuss about the statistics and data related issues, how they are misleading. So many things we discuss. And everything is required to precisely focus on the exam. Even we discuss the question paper. The ultimate objective is to perform into the exam, and I'm adding 2 words, without confusion. Confusion is the very dangerous thing. And it is, the antithesis of the confusion is the clarity. So either you are confused or you are clear. There is no state in between. These are the binary, either 0 or 1. No 0.1. It's a binary. Toss, if you will do the toss, either head or tail, nothing in between. If you are putting your finger on switch, either on or off, nothing in between. These are the binary. Like you are confused or clear. So only reading is not enough. Before reading, always in your mind, there must be in background, keep in your mind, you have to going to put your energy to clarify and complete clarify your doubts. On that particular point, you are not confused. You are so much clear that you can answer the queries of the court and client. Am I right or wrong? And ultimately, you must have to ask from yourself, at least on this point, are you clear? At your own satisfaction level. That's what I want to demonstrate today. It would be confirmed or test your understanding by way of answering the question asked. Soman Aditya, please. So it would be tested once you are able to comfortably answer the question asked in the previous year exam. We have almost 15 footprint of the previous year exams. Am I right or wrong? At least 15 साल के क्वेश्चन तो है ना. और कहीं ना कहीं जो टॉपिक आपने पढ़ा है उससे क्वेश्चन कहीं ना कहीं तो पूछा ही गया होगा. If you understand at your satisfaction level, you cleared your doubt, you are satisfied with your own, or you have a little bit doubt. If you will enter into that question, find out that question, sit and answer that question, it will give you the enormous confidence and the sense of completeness. Now you have completed this part. Then thereafter, it is confirmed to the understanding. Thereafter, the another level of work would start to optimize them. How to answer into the minimum word. Which point have to write, which point is not required to write, which maybe may not be. Then third level is this, you need to enter into the time frame. Within 5 minutes, how much I can write or not. Then the situation would be under your control. So that sort of layer you have to change. Of course, sometimes it would be the interconnected between the 2 points. So far ahead we have to go. Far ahead. Let us complete at least this part at the one level, then we'll go to the another level and third level and fourth level and so on and so forth. Lot of time is hijacked by the other persons. Please come out of that. Take control of your own driving seat in your hand. Don't give them till the exam. Thereafter, you are free. You know what I can say. Done for the day. Anyone want to say anything? Please. Mhm. Absolutely, absolutely. Mm. नहीं अजय जी मैं बिल्कुल so what I feel on that day I'm struggling to something improve in the thought process, you know. It's a very difficult part
Sir,
and
sir.
that is also the part of that, you know, that वो ये वो हिस्सा है ना जहां से लोगों का एक ईज कन्वीनियंस आ जाता है कि चलो मैं आ गया, मैंने मैंने यहां से लिया और अपने बैग में डाल लिया. So that sort of thing. but the combination of these two is required. So I realize that lot of burden what is I am keeping in my mind, it is released
Thank
because
you, sir.
sir's, supplementing supplementing that part.
मैंने एक यूट्यूब देखा था, एक लड़की है, यंग गर्ल, उसे पूरा कॉन्स्टिट्यूशन बड़े अच्छे से, यू कैन फ्लाई डायरेक्टली फ्रॉम यूएस यूजिंग स्पेशल, दैट इज फ्रॉम 1 to 22 के जो है आर्टिकल्स. फिर उसके बाद मैगी, सब मैगी इज गुड टू ईट एंड ऑल दैट. सो पार्ट टू,
People are
second part.
they are very
People are
creative,
doing a marvelous, like you can remember, memorize. Reddy sir
but
has given us Reddy
but
sir has given us a way to think. And Ajay ji is very मतलब मेरे भी दिमाग में वही आ रहा है. It is not that we need to copy somebody, but he has given us a direction that you can create your own thing. You can create.
मैम मैंने सर को दूसरे डायरेक्शन में इंडिकेट किया, वो सर समझ गया और मैं समझ रहा हूँ. आप लोगों को भी मैं थोड़ा एक्सप्लेन कर दूं. वन लेवल, वन थिंग, टू थिंग, थ्री थिंग्स इज अ डिफरेंट थिंग. अलग चीज, ये छोटी छोटी चीजें कभी कभी हो जाती हैं. But once you are sitting to connect a series of things, it's a project. It's a project. It should not be erroneous. Lot of pain is required, and that's what the dictionary would be created. Am I right or wrong, sir? Which is acceptable for all.
So,
It's a huge
one,
project. If we are able to create such sort of project in a story of the entire paper, even
Very easy to understand.
can you think that if you will say someone a story, they will read the one page before stepping into the examination hall and enter and perform and out. That's the power of that project.
then before the examination, this book is enough, sir. It is. One has to keep one book for one mini book for one paper. Entire thing you need not carry tons of books. It is.
Exactly, exactly.
He had recorded in entire all keywords,
Of
capsules,
course, it
everything.
is in terms of the coded, but everyone has to be, the decoding part.
And if you should
Strict to
do
decoding.
regularly, sir. Day regularly, on and off is enough. It is once in a week, one revise it is enough. It is. Eh, Once
स्टोरी
in a week.
ऑल्सो वी नीड टू रिमेम्बर ना, लाइक एक स्टोरी जब हम पढ़ेंगे उसको समझेंगे, उसके बाद हमारे दूसरी स्टोरी भी वैसी आ जाएगी, बिकॉज इट इज ऑलरेडी प्रैक्टिस वी नीड टू डू. लाइक अगर इन्होंने एक स्टोरी बताई हमको, उसको हम बार बार कोरिलेट करेंगे विद द मेन थिंग कि हमने ये 22-20 जो है हमारे स्टैचूज हमको याद रखने हैं रिलेटिंग टू दिस स्टोरी. एक बार हो जाएगा, 2 बार हो सकता है हम खुद ही अपना स्टोरी बना ले, तो सो इट विल कम ऑटोमेटिकली.
गीता मैम, कैसा रहा आज का?
And one thing I'll tell you, sir. For
Good morning,
forming
sir.
as a memory, remembering a subject, it is there
Just
are
a minute.
principles behind it. Memory technique. For everything, there are principles are there. It is. With that principle, we go it. Like a constitution, also we have got a preamble. It is. So how to remember which principle will apply? That is the technique is there. I'll tell you the principles also. If you learn this principle, leave over this AoR examination, that will remember forever throughout your life. It is. And I taught this memory technique principle to my daughter while she was studying for IELTS. It is. And it has given a wonderful results. She was the topper of University of Pune, Savitribai University of Pune. She was IELTS topper. So
That's great. That's great. Let us
these are
hear with the
tested
हाँ,
results.
हाँ, other fellow. Geeta ma'am, please.
Ji, sir. Good morning, sir.
Good morning.
Yes, sir. Sir, as usual, beautiful, mind-opening.
So nothing special as usual.
No, your lecture is always special.
पद्मजा मैम, अब मैं सबको 1 by 1 ही टच करूंगा.
बहुत अच्छा है सर. वो केस में क्या डाउट है हमको, वो पूरा क्लियर हो गया सर.
चलिए, कुछ तो इफेक्टिव रहा. बिकॉज समटाइम्स आई एम बीइंग डाउटफुल कि पता नहीं आज का सेशन कितना इफेक्टिव रहा नहीं रहा.
Sir, जो discussion था normal के normally, the word normally, that was mind-opening. My normally and or that was mind-opening. So thanks to Sidhu sir. Sidhu sir.
And Bharti ma'am?
Yes.
Yes, sir.
आपका ओपिनियन आज के डिस्कशन के बारे में?
नहीं सर, it was great. You have elaborated so nicely. अभी वो अपील कहाँ करना है वो एकदम क्लियर हो गया माइंड
समवेयर
में.
मतलब अटेंशन फोकस ऑन डॉट रहे तो ज्यादा अच्छा रहे, ये भी एक बैकग्राउंड में कोशिश थी.
What's sir? Not able to clear.
मैं ये कह रहा था कि कोशिश ये थी कि फोकस सेंटर्ड रहे, फोकस डाइवर्ट ना हो.
Right sir, right sir.
और कैसे मतलब हम मिसलीड होने से बचें,
हाँ
कहाँ पर
सर,
हम
वो जो
कैजुअल ना रहें, अलर्ट रहें.
राइट सर, एक छोटी सी मिस्टेक को एंड द कंडीशंस दैट इज वेरी मच रिक्वायर्ड कि हमारे को एकदम क्लियर होना चाहिए माइंड में, अदरवाइज वी विल completely do an error and we'll go on the wrong track.
स्वाति मैम, anyway, last but
Sir,
not
can I
least,
make a request? I mean, it's just a request.
yes, sure,
मुझे
sure.
yes.
Last
Sir,
but not
मुझे
least, now is your
yes.
turn, Swati ma'am.
Thank you, sir. सर मैं ये कहना चाह रही थी, आज की क्लास में मुझे ऐसा लगा कि from last Saturday to next Saturday we are giving a gap of a week in your class.
Yes.
And maybe कहीं disconnect हो जाता है. जैसे आपने कहा कि मैंने आपसे ये करने को बोला था, nobody has made that effort because morning we're doing a class and maybe with another member we're sitting in the evening and doing another session to the best of our ability. But my request and as per other members in the group agree, अगर एक आप और क्लास बीच में लें तो वो डिस्कनेक्ट जो हो रहा है and we'll be on track if as per your convenience, sir.
Ma'am,
That is my suggestion and my request.
what is my practice or even the culture, मतलब इस सेशन के बारे में मैं आपको ये बताऊं, मुझे अभी ये जो मैं क्वेश्चन रेज कर रहा हूँ ना, आई एम नॉट यूज्ड टू रेज क्वेश्चंस. ये मैंने इंटेंशनली रेज किया है टू टेस्ट समथिंग दैट. दो तीन चीज मैं आपको बताऊं. ये सेशन 5 o'clock मॉर्निंग है, ये फैक्ट है. शिवानी मैम इंटरेक्शन में आते हैं प्लीज.
जी सर, जी सर,
म्यूट ना करें.
जी सर.
ये जानबूझ करके रखा हुआ है कि हु इज द सिंसियर, राइट? एंड आई एम डैम श्योर एंड फुल्ली अवेयर अबाउट दैट. बहुत ऐसे लोग हैं जो इस टाइम को मैच नहीं कर पाते, बट दे आर ईगरली वेटिंग फॉर द वीडियोस.
Right, sir.
Whoever in the group and someone is outside the group, मतलब जो जिनका ग्रुप से कोई कनेक्शन नहीं है, वो सिर्फ वीडियोस का वेट करते रहते हैं. और कई बार उन्होंने पर्सनली मुझे फोन किया है, मैसेज किया है, फीडबैक मुझे आते रहता है. एंड माय फोन इज फ्लडेड विद दिस, मतलब व्हाट्सएप ग्रुप. अब दूसरी बात ये, मुझे एहसास है कि इस नॉर्मल पीरियड में लोग कहाँ पर लाइटर मोड में चले जाते हैं, अदर चीज हावी हो जाता है. बट ऑब्जेक्टिव एकदम क्रिस्टल क्लियर है कि मैं वहां पर थोड़ा सा अलर्ट मैसेज आप लोगों को कम्युनिकेट करूंगा बाय वे ऑफ दिस, जैसा मैंने आज किया, सो दैट यू कैन कीप ऑन दैट पर्टिकुलर पार्ट. आपने देखा होगा सिंस लास्ट 7 और 10 और सेशंस, जब से आप लोगों का पैरेलल सेशन शुरू हुआ है, पहले हमने वो पैरेलल सेशन को इन्वोक करने के लिए कहा था, अब वो इन्वोक हो गया. नाउ अब उसमें चल क्या रहा है, मैं तो वहां डेली जा नहीं पा रहा हूं. हाउ डू आई कंट्रोल देम? तो मैं आपके इसी थॉट प्रोसेस को मैं प्रिसाइज रखूंगा बाय वे ऑफ रेजिंग सर्टेन क्वेश्चंस. अच्छा, आप ये क्या कर रहे हैं, आप वो क्यों नहीं कर रहे हैं? तो ऐसा कहने के बजाय इनडायरेक्टली आई एम गिविंग यू द सर्टेन क्लू कि अब इस पार्ट को आप करके फिनिश करो. अब आप अपने धुन में पड़े हुए हैं, अब मैं कैसे आपका अटेंशन अट्रैक्ट करूं? तो दिस इज द गुड वे टू हिट ऑन द पॉइंट. तो So it's a well strategic and aligned. हमेशा मेरा अभी कोशिश ये है कि आप लोग क्वेश्चन पेपर लें और क्वेश्चन पेपर को करें. That is the ultimate part. You know, there is something word is the reverse engineering.
राजू जी, मैं एक बार आपको बता दूं, शिवानी जी
एक मिनट, let me complete. There is a word certain reverse engineering. यहाँ पर लोगों का एक टेक्निक होता है, either top to bottom और bottom to top और random. 3 मेथड है रिसर्च का. यदि किसी चीज को समझना है, इंटायर वर्ल्ड ऑफ रिसर्च, डॉक्टर साहब तो बहुत सारे पीएचडी की डिग्री ले रखे हैं, सो एवरीवन विल अवेयर अबाउट दैट, कि या तो मैं जैसे कॉन्स्टिट्यूशन की बात मैं करूं, कॉन्स्टिट्यूशन का एक आर्टिकल को पकड़ूं और उससे रिलेटेड जितने जजमेंट है उसका मैं ट्री बनाता चलूं, तो वो पीछे चलता चला जाएगा, अप टू डेट एक लंबी ट्री बन जाएगी. या फिर हम पूरे ट्री से ट्रेवल करते हुए सोर्स ढूंढते हुए जड़ तक आ जाए और आर्टिकल तक अप्रोच करें, या फिर रेंडमली एक दो चीज बीच में लें और ये करें. द स्ट्रक्चर्ड मैनर इज टॉप टू बॉटम और बॉटम टू टॉप. बट द रिवर्स इंजीनियरिंग में क्या होता है कि कुछ एलियन चीज हमारे पास आ गया, अब मैं उसके हर एक कैरेक्टर को एग्जामिन करना शुरू कर. दिस इज द टेक्निक्स इन आवर AoR एग्जामिनेशन. द टेक्निक इज आफ्टर सम एडवांस लेवल, जब आपको करना क्या है कि क्वेश्चन पिकअप करना चाहिए. अल्टीमेट पार्ट इज द क्वेश्चन, राइट. और क्वेश्चन से पीछे जैसे ही आप क्वेश्चन पिकअप करेंगे रेंडमली, निश्चित रूप से उस क्वेश्चन में कुछ चीज आता होगा और कुछ चीज नहीं आता होगा. और योर टेस्ट गाइडलाइंस आर फिट इन योर माइंड. नाउ यू विल स्टार्ट रिवर्सिंग देम कि ये चीज कैसे मुझे याद रहे. देन यू विल कंसल्ट द बुक एंड क्लोज दैट पर्टिकुलर क्वेश्चन. एक निश्चित सेट ऑफ क्वेश्चंस है, वही पूछे जा रहे हैं, स्पेशली इन पेपर 1 एंड पेपर 3. 1 and 3 में आप जाएंगे ना, सेट ऑफ क्वेश्चंस बहुत क्लियर है. जितने भी क्वेश्चंस अभी तक पूछे गए हैं, इवन द सेट ऑफ क्वेश्चंस, इवन द टाइप्स ऑफ क्वेश्चंस, इवन द नेचर ऑफ क्वेश्चंस, आपको एक कंप्लीट फ्लेवर ऑफ दिस एग्जामिनेशन दे देगा. एक उसकी एक यूनियन सेट आप बना करके देखें. इसीलिए मैं कहता हूं कि इफ यू रेड द आर्टिकल 136, just travel to all the questions asked from 136. It's a different project. यदि आप वहां जाएंगे तो बहुत कुछ ऐसा होगा जो पढ़ के आप स्किप करेंगे, लेकिन वो आपकी नजर से गुजरेगा जरूर. कहीं ना कहीं आप रुकेंगे, उसको कलेक्ट करेंगे, उसको सोचेंगे पहले कि क्यों मैं इसको कलेक्ट करूं. और ये सारा काम होता है एग्जाम के समय. तो ये क्रूशियल कोर्स सेंट्रिक पार्ट वो आज के डेट में हो, वो मैं चाह रहा हूं, और वो आपके डेली के सेशन में हो, कलेक्टिवली सबके द्वारा हो, वो मैं चाह रहा हूं. एम आई क्लियर और नॉट? और मैं ये भी चाह रहा हूं कि आप लोग बिना क्लियरली कहे मेरा हिंट को पिकअप करें. तो क्योंकि वो क्या है ना, मैं थोड़ा शर्मीले किस्म का इंसान हूं, शायद इसलिए. शिवानी मैम.
जी सर. जी सर.
तो आपके माध्यम से मैंने अपना पूरा इंटेंशन क्लियर कर दिया. और इनफैक्ट ये कहें कि
मैं वो शिवानी जी ठीक कह रही हैं कि आप एटलीस्ट 2 क्लासेस तो दे दो, 2 क्लासेस सिर्फ एटलीस्ट दिस.
अरे हाँ, वो दूसरा पार्ट तो छूट ही गया, दूसरा पार्ट तो छूट गया.
जजमेंट्स
January and onwards, January and onwards it will, January or February, January and onwards it will come on the not only the 2, on the 5 a day. पहले एक बार मैं रिजल्ट का वेट करूं, थोड़ा सा रिजल्ट तो आने दीजिए, क्लियरिटी आ जाएगी कि किनको क्या रोल देना है. बहुत लोग यहाँ पर हैं जो शायद वो उससे बाहर निकलेंगे, जैसे हमारे अजय जी, और वो हमारे दूसरे साइड में आकर के हमारी मदद करेंगे. तो रिस्पॉन्सिबिलिटी उनके लिए भी अवेटेड होगी, स्पेसिफिक असाइनमेंट होगा. तो वो डिफरेंट माने रोल इन सेंस ऑफ रोल. अजय जी, अभी क्या है ना, मैं आपको रोल असाइन कर नहीं सकता, बिकॉज यदि एग्जाम वर्डन है उस समय आपका अटेंशन ड्रैग करना, मैंने उससे बड़ा पापी मैं होऊंगा नहीं। ऊपर वाला लिखता है, सुना है मैंने, पाप पुण्य का हिसाब किताब होता रहता है, थोड़ा मुश्किल हो जाएगी मेरे लिए। द क्वेश्चन इज दिस कि जस्ट वेट फॉर द रिजल्ट। रिजल्ट के बाद मैं डबल ट्रिपल सब करूंगा, और यकीन मानिए जितना आप लोगों ने एक्सरसाइज किया है, एवरीथिंग आई विल कवर, नथिंग विल लेफ्ट। एंड माय फर्स्ट अटैक वुड बी ऑन दिस लीडिंग केसेस ओनली, क्योंकि ये मैंने ये रियलाइजेशन है कि सबसे ज्यादा अटेंशन, टेरर और डर जो भी बैठा करके रखता है, कंफ्यूजन, ये लीडिंग केसेस ही है। वंस इट वुड बी क्लियर, 90% वर्डन वुड रिजॉल्व, फिर मेरे लिए बड़ा आसान है, फिर तो मैं बड़े आराम से बाकी सारे ये लीडिंग केसेस कुल मिला करके 25% वेटेज रखता है, बट 90% प्रेशर और अटेंशन पे कब्जा करके रखता है। अब बाकी 10% में बाकी 3 पेपर जाते हैं। पूरी तरीके से बहुत सारे लोगों को अदर ध्यान देने की जरूरत भी नहीं बने। मैं आपको बताऊं, ड्राफ्टिंग के लिए लोग प्रैक्टिस तक नहीं कर पाते, क्योंकि उसकी कोई सिलेबस नहीं। इट्स इम्बैलेंस ना। करेंगे हम, उसको कवर करेंगे, सर्टेनली आई विल डू, बट गिव मी फॉर दिस मंथ ऑफ दिस जनवरी, sometimes we can say in February also, because February के second week में मेरे बेटे का बोर्ड का पेपर है, तो उनके साथ भी मुझे थोड़ा बैठना पड़ेगा। बट certainly I'll commit you March and onwards, मार्च अप्रैल मई 3 महीने हमारे पास होंगे, 5 days a week. Ma'am, how is that idea?
फैंटास्टिक।
शिवानी मैम,
जनवरी से
Yes, sir.
जनवरी से शुरू
Thank you.
कर दो आप, जनवरी से।
नहीं मार्च रख लीजिए, क्योंकि फरवरी उसका पेपर है, वो बहुत क्रूशियल है, उसके लाइफ का पहला और different exam है, तो responsibility and all these things we have to teach them and we have to feel them। मैंने मुझे भी दूसरा बार 10th देने का मौका मिलेगा उसके साथ। I don't want to lose it। He inviting the full attention, but at the same time weekly मैं यहाँ भी connect रहना चाहता हूँ। आप लोग कंटिन्यू रखिए, और आप लोगों को भी अलाइन रखना चाहता हूँ, so that's what बीच में मैं कुछ छेड़ता रहता हूँ जहां मुझे लगता है कि फोकस यहाँ होना चाहिए, देन आई एम इनवाइटिंग योर अटेंशन टू कीप ऑन फोकस। ठीक है, चलता रहे, जरूरत पड़ी तो हर हालत में एंटर करें।
वेलकम सर।
ओके, एंड आई एम डैम श्योर उस समय जो अभी फ्रीक्वेंसी यहाँ 29 और 36 के आसपास दिख रही है ना, ऑन दैट पॉइंट ऑफ टाइम इट विल टच अप टू 100, क्योंकि रिजल्ट आ चुका होगा, बहुत सारे क्योस क्लियर हो चुके होंगे, तो कहानी एकदम साफ सुथरा रहेगी। जिनको फॉर्म भरना होगा वो माइंड मेकअप कर चुके होंगे, और मुझे ये नहीं बोलेंगे कि सर फिर से रिपीट करो। ठीक है, तो आई फाइंड आउट, मैं ये जो एक्सरसाइज मैं आपसे करवाना चाहता हूँ, आई विल डू माई सेल्फ। वो करके निकाल करके एक जगह रख करके उसको कनेक्ट एंड कंपेयर करके, ये सारा कुछ जो मैंने अभी ऑनलाइन डेमो रखा है, वो डेमो की रिक्वायरमेंट नहीं होगी। ये सारे टाइम बचेंगे, फोकस पे हम लोग डिस्कस करेंगे। बंसर साहब,
यस सर।
कैसा, सही था आइडिया या फिर?
मैंने आपके आइडिया हमेशा अच्छे रहते हैं, इनोवेटिव रहते हैं, टेक्निकल माइंड भी रहता है, लीगल माइंड भी रहता है, तो 2 heads are always better than 1।
Okay, let us talk with the Rajada sir and close this meeting for the day.
Yes, sir. The session is very good, sir, and very innovative, sir. We are very hopeful.
आपने नोटिस किया, आज मैंने पहली बार बाकी सारे लोगों को टच कर रहा हूँ। Do you know why? So my intention is to be interactive, please.
To activate each and every person.
Okay. So have a nice day.
Thank you, sir.
Let us close this session for the day.
Thank you very
We'll
much.
come on the
Thank you, sir. Have a
22nd.
nice day.
Good day, sir. Good day, sir.